Today, we're busting a myth about the Supremacy Clause. Supporters of the monster state want you to believe that when the states push back against federal power in any situation, that the Supremacy Clause applies. But there are certain areas where the states can actually resist and say no to federal programs, and the Supremacy Clause doesn't even apply. It's under a legal doctrine known as anti-commandeering that's rooted in the ideas of the Founding Fathers and actually repeatedly upheld by major opinions of the Supreme Court. So on this episode, I'm going to explain this important 10th Amendment tool, which empowers the states to say no and opt out of enforcement of federal programs and regulatory programs without having to win or even have a debate about the constitutionality of those programs. But first of all, before getting to that, welcome and thank you for joining me here on the path to liberty. I'm Michael Bolden with the 10th Amendment Center, and this is the show for Monday, May 27th, 2024. I hope you and your family are having a happy Memorial Day. I really appreciate you spending some of your time with me today, and I hope you have an opportunity to remember and honor anyone that you have lost. But let's get right to this. I want to start out with a little background, and we have to understand that a big reason that many of the Federalists gave for needing the Constitution rather than the Articles of Confederation was because, in their view, the Articles gave them too many situations where states were needed as an intermediary. So if Congress wanted to do something, fund something, they'd have to go and ask the states. And if the states didn't go along with it, Congress couldn't do anything. And so to the Federalists, this was a serious problem. To those who really called themselves real Federalists, those who are named anti-Federalists, they saw this actually as an advantage. But here's Alexander Hamilton, I think, giving a very good argument where he's, not necessarily that he was right, but he's complaining about it here. He's explaining the scenario. In Federalist number 16, he wrote, "If the interposition of the state legislatures be necessary to give effect to a measure of the Union, they have only not to act or to act evasively, and the measure is defeated." Now, this is for us a strategic advice today. So anytime the federal government relies on state legislatures or state governments or state executive branch to implement a federal act or a regulatory program, all they have to do is exactly what Hamilton was complaining about. They only have to not act or act evasively, and the measure is defeated. He understood that, but this is not what he wanted. He was pointing out, okay, we want this system to act on individuals instead. And on the other end of the spectrum, one of the most hated ways that this played out was under a system called the tax requisition system. Okay, this state has to put in this much money for taxes, and this one has to do this much, and this one has to do this much based on our formula. And you just have to go out and figure out how to collect those taxes from your people and then turn it over to us in Congress. Now, on the anti-federalist side, I think Patrick Henry was the most anti-federalist on this particular thing. He was one of the few that actually really cheered this system on. He actually argued in favor of the tax requisition system, calling it one of the most important political checks on centralized or federal power. Basically, if they ask for money and the states think it's too much, then, well, they're going to have to ask for less, or they're maybe going to get nothing. And so Patrick Henry loved that system. The Federalists hated it. Many of the anti-Federalists there weren't a lot of people who loved that one, but I covered it in some detail in an episode called Tax Battle: Henry versus Hamilton on the requisition system last April in 2023. That'll be in the show notes, which I'll get to in just a moment. But back to Hamilton. Here he is in Federalist number 16. He said, "If the execution of the laws of the national government should not require the intervention of the state legislatures, if they were to pass into immediate operation upon the citizens themselves, the particular governments, the states that is, could not interrupt their progress without an open and violent exertion of an unconstitutional power." Alexander Hamilton and many of the other Federalists, of course, he was probably most prominent on this particular issue, were arguing against any scenario where the federal government relied on the states to implement federal acts or regulatory programs. They thought it was a terrible idea to do that. Now, today, that's pretty much what they do with everything. So even for the big government people, they thought this was a bad way to have big government. You just have to be able to find a way to have your big government operate directly on the people without having to have the states do stuff. And so that should tell you how big the government is today, the largest government in history, and I'll get to more of that in a few as well. But if they're having to rely on states to implement federal programs, they're so big that they can't even cover all the crazy stuff that they're doing. They're in a serious problem. Anyway, so Hamilton is saying we don't want a federal government, a general government, or a central government that needs the states at all. He wanted to get rid of the states completely. He thought they could just be kept around as long as they were kind of subordinatively useful, as long as people were freaked out about getting rid of them. So he didn't want a system where states were involved at all. So he said no omissions nor evasions would answer the end. So if the states wanted to interrupt things and the federal government didn't even need the states to implement something, it doesn't matter what the states did. The federal government would be able to do what the federal government wants. That's exactly what Hamilton wanted. Oliver Ellsworth, one of the first chief justices on the Supreme Court, I think he was number 3, he made the same kind of case in the Connecticut Ratifying Convention, January of 1788. They got rid of the system that called for the states to help the federal government. The entire Constitution was designed and sold to the people as something that would act directly on individuals, and it did not require the interposition of state legislatures, state governments in any ways to implement, effect, or enforce any federal acts or regulatory programs within of course, their limited delegated powers. And so this is how future Chief Justice Oliver Ellsworth put it. He said, this Constitution does not attempt to coerce sovereign bodies, states, in their political capacity. Oh, I don't have the images up on the screen here. There we go. This Constitution does not attempt to coerce sovereign bodies, states, in their political capacity. Now, this is something that the Supreme Court we don't generally get a lot of wins out of the Supreme Court. Maybe there's one every few decades. And when they do, of course, we want to cheer that. But we don't want to wait on the Supreme Court to tell us to do what we're already authorized to do. But anyways, the Supreme Court has actually run with this viewpoint that Hamilton was against. He did not want the federal government having to rely on the states. And Oliver Ellsworth made very clear that the states were not able to be coerced by the federal government. And they've put something together and built into a legal doctrine under Supreme Court precedent for many, many years called anti-commandeering. And I've covered that on this show many times. So I want to add this little supremacy clause twist to it that we're getting to here in just a moment. But Meharry puts it this way. Mike Meharry says, the Supreme Court has long held that states do not have to actively participate in the enforcement or effectuation of federal acts or regulatory programs. In other words, the federal government gets to do stuff within the powers delegated to the federal government. Now, of course, the federal government people read that really broadly. So let's set that aside. Let's say they can do everything under the sun except 5 things. Well, in the everything under the sun minus those 5 things, the federal government, if it wants to do it, the federal government has to have the resources and person power to implement it. The states don't have to do it. And the Supreme Court has agreed on that many, many times. And here's a quick overview of those main cases. First, in 1842, Prigg versus Pennsylvania, Justice Joseph Story, who was not good on the Constitution but got this part of it, this narrow part, right, he held that the federal government could not force states to implement or carry out the Fugitive Slave Act of 1793. He said it was a federal law, and the federal government ultimately had to enforce it. Quote, the states, therefore, cannot be compelled to enforce them. And this is something that was used. The states ran with this. And they said, well, if even the Supreme Court is saying we don't have to help enforce the Fugitive Slave Act, and they passed all these things called, well, they already had been doing this, but they really built upon that within that framework to pass these personal liberty acts in the North, talking about how they weren't going to participate in enforcing the Fugitive Slave Act, both of 1793 and of 1850. And if you've listened to me cover that episode, that on many episodes on the show, you know that they were very effective in that. Whether the southern states liked it or not, or the northern states liked it or not, what they tried to do was bring those federal programs to a halt, and they were very successful by not implementing those things. So Prigg versus Pennsylvania was really the first one. New York versus U.S., most legal people will tell you this is the beginning of it. They don't even point out how Hamilton was talking about this or how Oliver Ellsworth was talking about not coercing sovereign body states and their political capacity. They don't talk about Prigg versus Pennsylvania because it was dicta. It wasn't, the official ruling, but it was part of the whole system, and everyone followed that approach. So they always point to New York versus U.S. in 1992. And that's where the court held that regulations in the Low-Level Radioactive Waste Policy Amendment Act of 1985 were coercive, we're thinking of what Oliver Ellsworth said, and violated the sovereignty of the state of New York. And here's how Sandra Day O'Connor put it for the 6-3 majority. As an initial matter, Congress may not simply commandeer the legislative processes of the states by directly compelling them to enact and enforce a federal regulatory program. Period. And she went further. While Congress has substantial powers to govern the nation directly, this is the Hamiltonian argument, of course. She's taking a very broad, she generally would take, maybe not as bad as some of these people today, but most modern justices take a very broad view of federal power under the Commerce Clause, general welfare, necessary, proper, all kinds of stuff. And they really love their stare decisis, their precedent, which has all been really bad in modern times. But even though she's making the case that the federal government has all kinds of broad powers, she's really hammering home that if the federal government wants to do something, the states don't have to, they can't be forced to help. She said, while Congress has substantial powers to govern the nation directly, including in areas of intimate concern to the states, the Constitution has never been understood to confer upon Congress the ability to require the states to govern according to Congress's instructions. And possibly the most well-known case on this up until at least recent years is a kind of a gun control case against the Brady Act. This is Prince versus U.S. And Justice Scalia wrote for the majority in this one. It was a close one. I think it was 5-4. He said, we held in New York, that's the 92 case, that Congress cannot compel the states to enact or enforce a regulatory program. So they're just reiterating this. And then he said, today, we hold that Congress cannot circumvent that prohibition by conscripting the state's officers directly. They couldn't require sheriffs to do the things that the Brady Act wanted them to do, for example. The federal government, he said, may neither issue directives requiring the states to address particular problems, nor command the state's officers or those of their political subdivisions to administer or enforce a federal regulatory program. We'll hear this over and over and over. We also have NFIB versus Sebelius. This is the famous Obamacare case in 2012 where I guess it was a tax. I don't know what it was. Whatever they wanted to call it to keep it around. But at NFIB versus Sebelius, the court, Mike Meharry writes, held that the federal government could not compel states to expand Medicaid by threatening to withhold funding for those programs already in place. So basically, they're just saying, hey, if you've made an agreement to do this, we can't, force you to do more. This is more commandeering of the states if you don't voluntarily agree to do it. So it's really reinforcing the idea that the federal government can't make a deal with the states. And then even when they're funding stuff, if they make a payment deal with the states, you're going to get this if you do this. They can't just change those rules and say, well, you're getting money from us. We can tell you to do whatever we want. This has been reaffirmed in a number of other cases as well. And then the most recent one, I think, is a big one. Murphy versus NCAA. This is in 2018. This was a sports betting case in New Jersey, out of New Jersey. And in that one, the court held that Congress can't take any action that, quote, dictates what a state legislature may and may not do. They really did actually in some ways expand and really reaffirm this, especially because it was a 7-2 opinion in 2018. And if you think about the balance of the court at that time, you might be surprised. But here's how Samuel Alito put it for the majority. And it's a long piece, but it's important. The anti-commandeering doctrine may sound arcane, but it is simply the expression of a fundamental structural decision incorporated into the Constitution. The decision to withhold from Congress the power to issue orders directly to the states. Conspicuously absent from the list of powers given to Congress is the power to issue direct orders to the governments of the states. The anti-commandeering doctrine simply represents the recognition of this limit on congressional authority. So very, very straightforward stuff. We know from the founding generation that, and I cited Hamilton and Ellsworth on this, but there are many other examples of people like Roger Sherman, James Madison calling as strategically for states just to not participate in federal enforcement. We know the founding generation was totally on board with this structure. Hamilton thought you had to have this structure where the states weren't involved because it would lead to all kinds of really bad stuff for centralized power. He thought it was actually bad for centralized power, and that's exactly what they're using today as a bad approach. But anyways, this stuff, we'll link to all this in the show notes. I checked with Alan Mosley. He said he's going to pop in sometime this afternoon and get the show notes done for this episode like we do for every episode over at 10thamendmentcenter.com/path-to-liberty. That way you can read Mike Meharry's great article, which we've had published for a couple of years now, with an overview of the 5 major cases, the anti-commandeering cases. You'll get the original source document links to Hamilton and Ellsworth and others, plus other articles and episodes and stuff that I'm mentioning. That'll all, again, be over at 10thamendmentcenter.com/path-to-liberty. And while I'm here, I want to take a quick moment and say hello to everyone out in the live chat over on Rumble, Dennis and Render and Brewster and Gypsy, and everyone else. Gypsy likes the shirt. Yeah, this is basically, it's, for those of you who can't see the video, it's the text of the 10th Amendment with part of it redacted, which really kind of shows exactly how, well, they treat the 10th Amendment today. They basically have unlimited power. It's available over at shop.10thamendmentcenter.com. So appreciate you shouting that out, Gypsy, and everyone over on Rumble. On Facebook and YouTube and elsewhere, let's see who, if I can get this pulled up here. There's Cheriton and Kirk and Lewis and Ruben and Juggalos and MRGF, Tim Martin, and a bunch of other people. The Plumber Speaks. I appreciate you guys being here again, whether this is your first episode or you've been here for all of them. I'm not sure if I've been here for every single episode since day one, but I do my best. But let's get back to this, because I'm not going to keep you guys forever on this topic, but it's an important one. We're combining anti-commandeering doctrine, which is a 10th Amendment legal doctrine that says the states do not have to participate in the enforcement of federal acts. And if the states opt out and the federal government relies on it, as Alexander Hamilton complained, then the federal government isn't going to be able to get much done. And that's a very big problem for the empire today. But despite these facts, anytime we post a video, an article, a podcast, anything on this topic saying that states don't have to help enforce federal acts or regulatory programs, we get really arrogant, condescending, ignorant people commenting. Like this one we got on X a few days ago from a guy named Matthew Paul, who is a self-described civics teacher in Florida. This is the type of people that are teaching your kids. He's responding to a short video where Mike Meharry cited people like Roger Sherman and Ellsworth and others saying, this is what the Supreme Court has reaffirmed. And so his only response is, this guy has never heard of the Supremacy Clause. Of course, the argument to them is that anytime the federal government does anything, the states can't do anything that might run counter to the federal government's goal. And that includes, of course, they're saying, well, you can't interfere with the federal government. But even if the states say, well, we just don't want to participate, anytime the states do anything, we hear supremacy clause, supremacy clause, supremacy clause. And under the massive ignorance of the average person about the original legal meaning of the Constitution, most people have never even read the document, yet they're going to be in charge of pulling a lever or pressing a button for someone who's supposed to swear an oath to uphold that document. This is a really crazy system that we're choosing to live under at this point. They know nothing about this. So this is a very powerful argument for supporters of the monster state, people who love to twist the original legal meaning of the Constitution. They say supremacy clause, that means federal law is always supreme and states can't do nothing about it. And that's the mentality that people have. But let's read the supremacy clause. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary, notwithstanding. I didn't stumble over that. I haven't got it memorized. I don't know. I've read this thing so many times on so many episodes and so many articles. You'd think at some point it would get stuck in those old brain cells, but it doesn't. So the Constitution, if they're going, basically, if federal law is in pursuance of the Constitution, it is supreme over anything else that the states do contrary. But you notice that it says judges in every state shall be bound thereby. It doesn't say the states will be required to use their own resources to enforce those federal acts for the federal government, because we know for a fact having that system is exactly what the Federalists did not want. So the people who wanted bigger government rejected the idea of relying on the states to enforce that bigger government because they thought that was a weak point. As long as you had to rely on states, you couldn't get the big government or maybe if the states decided to go along, you could get it. But if the states changed their mind, it's very easy for them to bring that big government to an end. Thankfully, that's kind of the situation that we're in. Here's actually on the other hand, maybe not. Hamilton in Federalist 16, again, he vehemently argued against the system of relying on the states to effectuate federal programs, warning that doing that would eventually lead to a conflict in arms. He says, "It has been seen that delinquencies in the members of this union, the states, tax requisition, they're delinquent in bringing payments," he said, "are its natural and necessary offspring." So as long as the federal government has to rely on the states, it's naturally going to result in a situation where, some of the states or all of the states are not going to put up. They're going to evade. And he said that is the natural and necessary offspring. He said, and that whenever they happen, the only constitutional remedy is force, and the immediate effect of the use of it, civil war. So he warned that as long as the federal government relied on the states, just like they did under the Fugitive Slave Acts of 1793, they tried to commandeer the states to help enforce these slave-catching laws. They tried to commandeer them in 1850 as well, rather than just saying, hey, this is the process. Now, you're going to have to also give up due process and jury trials, and you're going to, if you can't choose who's going to be in the jobs, we're going to require you to do specific stuff. Now, the South, of course, argued that they were breaking their compact, but the structural important point here is that Hamilton specifically warned that as long as the federal government relied on states to implement federal programs, you'd end up in a civil war. And here, of all the things that I can't stand about Hamilton, I think he kind of called that one. Oliver Ellsworth made the very same argument. So did many others on the Federalist side. He said a necessary consequence of the principles of the people who want the federal government to have to go through the states to implement stuff, he said, is a war of the states, one against the other. So the end result we got in the Constitution with the Supremacy Clause was a general government that could pass laws that impacted individuals, not states. They told us over and over and over the federal government was not going to be coercive on the states and state governments. And as a result, if the federal government passes a law, as Story put it in that Prigg versus Pennsylvania case in 1842, it's up to the feds to figure out how they're going to enforce it. Now, we can, of course, have all kinds of constitutional arguments about all the stuff that they do, and that is valuable. But when it comes to states just saying, we're not going to help you, we don't even have to have a constitutional argument about it because we don't have to discuss the constitutionality of the act. The states can help the federal governments if that's how they want to spend their money, but they do not have to. And then on top of it, when states do opt out, and here from Murphy versus NCAA, again, that 7-2 opinion in 2018 written by Samuel Alito, reaffirming and expanding the anti-commandeering doctrine, the Supremacy Clause doesn't apply, and they specifically just said that at the Supreme Court. So there's no conflict between states and feds. There's no federal law is supreme and your state law to the contrary, because there is no state law to the contrary. And that's exactly how Alito put it in that 7-2 majority. He said preemption is based on the Supremacy Clause, and that clause is not an independent grant of legislative power to the states. It specifies that federal law is supreme in a case of a conflict with a state law. So preemption is when the feds have something on the books or it's part of the Constitution and the states try to do something that's basically the same field. They basically kind of invade the delegated powers of the federal government. However you're reading that, we're actually setting that aside. Like, for example, the federal government, Congress, has delegated the power to establish post offices and post roads. So it would be pretty easy, I think, for most people to make the case that if the states established post offices and post roads, Congress could say, hey, no, this is something that's been delegated to us. We're going to take you to court. And it's probably going to be the case that the Supreme Court's going to say, no, this is preempted. This is a Supremacy Clause conflict. Or Congress has delegated the power to declare war. What if a state decides to officially declare war against another country? Well, it's going to be pretty clear in the court case that, well, no, this is something that's been delegated to Congress, and there's a conflict. So the Congressional Act, the federal government, the Constitution, preempts the state law, and the state law is invalid. That would be how that process works out in some very generic terms. But anyways, Alito put it this way. Therefore, in order for the provisions of the act that was in question, PASPA, to preempt state law, it must satisfy two requirements. First, it must represent the exercise of a power conferred on Congress by the Constitution. Pointing to the Supremacy Clause will not do. Just straight out. They're like, we know everyone wants to say that, the federal government has supreme in this area, so the states can't even just say, we're going to do it differently. This is a situation where the states were basically trying to legalize something that the federal government was saying you couldn't legalize. So the federal government wanted to commandeer states into doing or not doing something. And Alito specifically said doing that, a more direct affront to state sovereignty, is not easy to imagine. So again, he said, second, since the Constitution confers upon Congress the power to regulate individuals, not states, that's from New York versus U.S., the provision at issue must best be read as one that regulates private actors. So if they're telling individuals what to do, then states, if they tell individuals what they, like something opposite, maybe that's a problem. But the states can't be told that they have to help the federal government. Again, just hammered home over and over and over in these federal court cases. So, and that's why really with these cases, this is why we don't see states like California and dozens of others losing a bunch of federal lawsuits over the fact that they have legalized a plant that the federal government says is illegal in every situation. Or we don't see Arizona and Montana and a few other states getting sued into oblivion for banning the use of state and local resources for helping enforce federal gun control. And then even in a lawsuit against a Missouri law, the Second Amendment Preservation Act, which I've covered many times on this show over the years. This is a very hostile court. This has been taken to federal court, and there's a very hostile judge that held against it. But even in the ruling, the opinion against the Missouri Second Amendment Preservation Act, the judge specifically said, no, the federal government can't require the state to use its resources to enforce federal gun control measures. We're just holding against it for other reasons. I think they'll end up losing. I think the federal government's going to lose on those other reasons. But this also reaffirms the view that even hostile courts, hostile to your right to keep and bear arms, hostile to the Second Amendment, hostile to the structure of the Constitution, hostile to the states, even those federal judges specifically reaffirm the anti-commandeering doctrine. So we see this over and over and over. And then on top of it, you get statements like this from the National Governors Association during one of these so-called shutdowns where they don't really shut anything down other than some parks or some ways to make things inconvenient to people in order to manipulate them into supporting the federal government spending more stolen money. But anyways, the National Governors Association complained about this at one point. If the federal government is shutting down, how are we going to implement programs? Because, well, states are partners with the federal government in implementing most federal programs. Now, of course, the National Governors Association was complaining because they wanted to continue implementing most federal programs. But the dirty little secret that we learn out of this is that, well, partnerships don't work when half the team quits. Partnerships don't work unless half the team quits. So ultimately, the federal government has created its own problem. They've passed so many rules and laws and regulations that they don't have the resources to enforce much on their own. And again, as National Governors Association says, most federal programs are enforced by a partnership with the states. I think this is incredibly important strategic information. We work to implement it all over the place. You can see how we do that in our annual State of the Nullification Movement report over at 10thamendmentcenter.com/report. It's like 150 pages. It's free download, all kinds of different formats. Well, all kinds might be an overstatement, but you can download that for free, 10thamendmentcenter.com/report. And if you want to help us reach and teach more people with this essential, foundational, and strategic information that can help us move forward to support the Constitution and liberty, whether the feds like it or not, they don't. Nothing helps us do this work more than the financial faith and support of our members. I'd be very grateful for any consideration you can give to joining us as a member today over at 10thamendmentcenter.com/members. Again, it starts out at just $2 a month of that dirty government fiat. So please consider throwing it our way. We also have annual, 5-year, and lifetime options. 10thamendmentcenter.com/members. And while I've got another moment or so, I'm going to take a look and see if there's any other comments or questions. Gypsy says, the federal government was created by the states, not the other way around. The states are the parents, the federal government, the mere child. And one clarification on that. This is correct. Now, James Madison explained in his report of 1800, for example, that when you talk about states, you can have various definitions depending on the context. And I'm sure Gypsy is, I've seen a lot of posts from Gypsy over the last few months, really good comments and quotes. But Madison pointed out it could be state governments, it could be a geographic area, but when it comes to states creating the federal government, he references it as the people composing those political societies. The people of the several states in their highest sovereign capacity are the ultimate authority, the creators, the parties to the compact. That is the Constitution. Thanks for that thoughtful comment. See if there's anything else over here. The plumber speaks, I'd like to see a state refuse to take federal authority over schools, or maybe to opt out of receiving funding. And then that's how, of course, they do this. They use this kind of carrot and stick approach. Well, we're going to steal this money from all your people, and then we'll offer it back to you because they operate on the people directly. And then, well, we'll offer it back to you. And if you say no to it, you're going to look really bad. And that is one of a very manipulative approach. But we certainly see this being implemented on a lot of stuff. Cannabis is one big one. Of course, there's 36 states basically that have said, well, we're going to legalize what the federal government prohibits. Maybe they should do that on suppressors or bump stocks, for example. We do see a handful of states starting to implement things like banning state and local enforcement of various federal gun control programs. Again, that's all covered over at 10thamendmentcenter.com/report. I'll scroll through some more of the comments a little bit later today, probably tomorrow. I'm going to take the rest of the day off, hang out with my lovely Sarah as much as I can, and some birds and things like that. But I really hope you enjoyed the episode today. I hope it made you think. I hope you learned something. I appreciate you being here, and I hope to see you next time on the path to liberty.